And we are recording. Chair Schmidt, would you like to introduce the meeting, or do you want me to?
I will defer to you, Ms. Leger.
This is the Sunshine Ordinance Task Force Complaint Committee meeting of December 21, 2021. The time is 5:32. This is a remote regular meeting. Listen and public call-in phone number 415-906-4659. Meeting ID 693-981-792#. If you wish to make a statement during general public comment, please press *6 and unmute your telephone to speak. Please press *6 to mute your telephone once you are done with your statement. Please also note that callers may now raise their hands by pressing *5. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency, the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment by teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Schmidt, do you want me to read meeting decorum, or would you like to?
I'll read it this time. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave.
Okay. Shall I read item number 1?
Yes, please.
Call to order, roll call, and agenda changes. Roll call. Member Stein?
Present.
Member Stein present. Chair Schmidt?
Present.
Chair Schmidt present. We have a quorum. Chair Schmidt, would you like to discuss the possible agenda change in today's agenda? Item number 11, the proposed changes to the task force procedures and bylaws.
Yes.
I think we discussed that we wanted to continue it to the call of the chair.
Well, what I want to do is this. Let me tell everyone up front that number 11, which is a hearing on basically some proposals about. I'm sorry. I need to see. It seems like someone is maybe speaking in the background.
Just a moment. If you are not speaking at this time, please press *6 to mute your telephone. Chair Schmidt has the lead right now.
Yeah, thank you.
Please press *6.
Okay, I think we're clear there.
Yeah.
Number 11, we will. I think what we'll do is we will call the item, but not for any kind of action, because some of the file was not placed more than 72 hours ahead of time. And as far as I know, that's my fault. the chair. But basically, we will just say what it is at that time and clarify as to what's going to happen with those items. But we will be moving them to a future hearing. So that is somewhat of a change in the agenda, but we won't be able to take any action as of today. So that is the one agenda change that I am aware of, Cheryl.
All right. Do we have other agenda changes? Member Stein, do you have anything that you would like to discuss under item number 1?
No, I'm good.
Okay. Okay, so I have taken notes on what you just said, Chair Schmidt, and note that when we get to item 11, we will have that we will recognize the item for what we've just discussed. Okay?
Yes.
All right. Shall I read item number 2?
Yes, please.
Item number 2, approval of the November 16, 2021 Complaint Committee meeting minutes.
Okay. Any anything that you would like to change, Member Stein? I have nothing.
Anything. Yeah, I didn't see anything either.
Okay. How about you, Cheryl? Well, I guess
I drafted the minutes, so I need, if you have comments or questions, sure. I'm happy to address them.
Got it. Okay. Well, I think then we can, I'll move to approve.
And I'll second that.
Okay. And then we can, Member Stein is seconded, and so we can go to public comment.
Public comment on the minutes. Right.
Public comment on the minutes. Do we have any public commenters? This is public commenters on the November Complaint Committee meeting minutes. Please press *6 to unmute yourself if you wish to speak.
Yeah, so far there may not be anyone who wants to speak on this item.
So shall we close public comment?
Yeah, let's go ahead and close that. Let's go ahead and vote.
All right. Member Schmidt?
Aye.
Member Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein to approve the November 16, 2021 minutes.
So when you're ready, Cheryl, we can move on to number 3, which is general public comment.
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Is anyone here who would like to submit general public comment?
Anonymous number 3.
Anonymous number 3.
Do we have other public commenters?
Let's go ahead with anonymous number 3, and then I'm not sure if we've heard from anyone else.
We can wait for anonymous
number.
When anonymous number 3's concluded his comment, we can call for it again.
That's fine.
Okay. Anonymous, are you ready to speak?
I am. Excuse me.
Go ahead, sir.
Thank you very much. This is anonymous number 3. So you discussed something in item 1 that you didn't take public comment on, so I'm just going to mention it here. I don't know if it's supposed to be fixed online because you said about 72 hours, but even right now there is only a 6-page attachment, which I think has always been there for item 11. So I'm not sure if you expected there to be more pages uploaded now, later than 72 hours, but there's nothing else I can see online other than the 6 pages that was always been there. So apart from that, I often update these committees on random interesting things happening in Sunshine. So while it is the case that the mayor and many of her department heads completely delete nearly every record that exists, they have produced 12 records ever since January 2020 that the mayor herself personally wrote anything in. It is the case that they did not realize there's this other computer system called Microsoft Teams channels and chats where those kinds of messages are recorded and you can sunshine them. And so if you ask a department to preserve and produce Microsoft Teams channels, chats, there's a thing called spaces, there's all sorts of these things, they can access them and they must therefore produce them. And it's a nice way to get at offices like the mayor's office who tries to delete everything. Thank you very much.
Okay, thank you. Anyone else for public comment?
Okay. I have a question.
We don't really answer questions at this time.
Well, it's not.
You want to make a public comment?
It's just a clarification. I'm one of the complainants.
You're a complainant.
Yeah.
Do you want to make public comment?
No, just want to make sure that I understand how to be present for a hearing of my matter.
Is this Mr. Severnov?
Yes.
Okay. I think that we will likely be going forward with your matter, but it will be called in order. So
Okay.
that is, let's see, it is number
10.
Oh yeah, number 10 on the calendar. Yeah. It will be a little while till we get there. Okay.
Sure.
All right. Thank you. And I believe that there may not be anyone else for public comment. And so I will say that to Anonymous 3, item 11, I thought that the number of pages that would be attached would be approximately 13 or 14. I don't quite remember exactly. And that would be composed of Anonymous number 3, 2 pages, Sullivan 5 pages, and then I had drafted a response to those, and that's 6 or 7 pages. And those were the items that were intended to be attached there. I don't know what's in there now. Can I ask you, is it my item that's in there, or is it the other 2?
It is. Sorry, this is Anonymous number 3. It is one 5-page document from Mr. Sullivan, and neither your part nor I guess my part are in there. So.
Okay.
Yeah.
All right. And I'll ask Cheryl, because I thought that somehow it had been altered in the meantime. Cheryl, what was there?
Mr. Sullivan's statements were originally submitted for this particular item.
Okay.
And when I saw your email, that's when you and I had a conversation yesterday afternoon.
Yes.
I substituted in your records for Mr. Sullivan, and that's when we discussed that these particular materials would have had less than 72 hours to be posted, and that it wouldn't be appropriate. So that's when we decided we would continue item 11.
Okay, so my my document is not available as part of the attachments at this time.
It's
Okay.
not online.
Okay. Understood. So in that case, Well, I will just say that I had drafted a response, and it's something that I would like to distribute. I had hoped to distribute it in that way. It may be that it goes just to the next complaint committee meeting, but I'll need to think about how I want to do that. And I certainly want to get that to Member Stein from this committee very soon. I apologize for my mistake, which led to it not being available today. I had not necessarily intended that there be action taken, but I did want to highlight Anonymous 3 and Mr. Sullivan's contributions, because I thought they were significant, and that's why I wrote a response to their contributions. So I'm going to, in the meantime, between this meeting and the next meeting, I will act and determine what I want to do with that. Okay, that's okay, so I think we've concluded the public comment section. Ms. Leger, I think we can move on to the next item.
Item number 4, file number 21141, complaint by Claudia Ovalis against the Office of the District Attorney for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner. As you will recall, committee members, this matter was scheduled for last month. Ms. Ovalis was present then, but the District Attorney's Office representative was not. Ms. Ovalis asked, or we told Ms. Ovalis that we would have her matter heard first this evening because she's calling in from the Midwest and is on a different time schedule.
Okay, and so we can go ahead. Let me see who is here. Ms. Ovalis, are you speaking tonight?
I'm sorry, I've already addressed you all, so I wasn't sure if I needed to readdress.
Got it. I'm going to ask for 3 minutes from each of the parties. And is there anyone here for the District Attorney's Office?
Yes, Robin Burke from the District Attorney's Office.
All right, thank you. And it's not mandatory that people take the full 3 minutes, but we're just asking for sort of simple introductory statements from each of the sides, and then we may have some questions. But we've already looked at all the paperwork, and so we are familiar with the matter. So, Ms. Ovalis, I apologize if I'm asking you to repeat yourself, but I will give you a chance to speak to us again about your matter. When Cheryl's ready.
Ms. Ovalis, are you ready to begin speaking?
Yes, ma'am, I am.
Go ahead, ma'am.
Yes, I'm just basically here because I submitted a request via email to the District Attorney's Office back on March 9th, and I did a few follow-ups between their office and Victim Services, which I believe is a division or department within the District Attorney's Office, but I've never received any acknowledgement whatsoever that my public records request was received or that it was being worked on or anything like that. And I know there's a certain timeline to respond to any request, but I've even till now have not received anything back.
All right. Thank you. Okay, Ms. Burke, when Cheryl's ready.
Yeah.
Ms. Burke, are you ready?
I am.
Go ahead, ma'am.
So we responded to all of Ms. Ovalis's complaint or requests. I believe there were 3, and it was for records relating to a report that she'd made to the San Francisco Police Department and I sent a response to every single one of them. And so I'm not sure if there was a problem with her receiving the email. I'm happy to send them again if she didn't receive them, but I was unaware that they weren't received. I forwarded them to the Sunshine Task Force as well, so you should have record of them.
Okay, thank you. Now we may have questions for the parties, and I will ask if Member Stein has anything to ask at this point.
I just have a couple questions for the petitioner and one for the respondent. For the petitioner, so let's see. You still to date have not received any documentation related to the SFPD case?
That is correct.
Or any documentation related to the case number that you gave, correct?
Correct.
And you did not receive the DA's response letters?
By mail?
Yeah, by email, because it appears that they were sent to the same email that that the SOTF has been corresponding with.
No, not to my knowledge. I haven't received anything. Otherwise, I would have attempted to cancel this process. So I don't have any record of that. And I've also called, and my calls are not returned either. So I just don't know.
Okay, and do you have any documentation showing that this case was transferred to the DA's office or indicating that they have the records that you are looking for?
Yes, Sergeant Andrea Creed at the San Francisco SVU was the one that made me aware that it was sent to the District Attorney's office back in January of 2021, I believe.
Okay. And then I just have one question for the respondent, which is, do you make transcripts of phone calls?
We do not.
Okay. Those are my questions.
All right. I have a question first for the petitioner. There are 3 April 2, 2021 letters in our file, where the district attorney addressed you, Ms. Avalos, and with your email address. And these are responses that, have you seen those in connection with today's hearing?
No, sir, I have not.
Okay, and so you can you tell us whether you ever received those letters that are dated April 2 from the district attorney's office?
No, I have not. I'm looking at my email right now, and I don't see anything from April 2nd from the district attorney's office.
Okay. And I will now ask Ms. Burke. It certainly does appear with these letters that you had the right name and apparently the right email address. Can you tell me if you have anything that indicates that these were actually placed into the email, to that email address?
I responded myself, and I responded directly to the email from Ms. Avalos.
Okay, so you can tell us today that you could locate the actual emails which were addressed to her address.
Yeah, when I responded to this committee last week, I pulled up the email that I had sent and forwarded that directly. So I was able to find it last week. Unfortunately, I'm in transit right now in my car, and so I can't pull it up on my computer but I should be home in the next 10 minutes, and I can resend it to Ms. Ovalis then and CC you as well.
Understood. Okay, thank you. I don't have any further questions. So at this time, we've heard from the parties.
Can I ask one more question?
Oh, yeah.
I just want to clarify whether Ms. Ovalis actually received our packet that has, these materials in it, or whether she doesn't have the packet.
Oh, I'm sorry. Which packet?
The packet for this hearing. I mean, for this review.
Yes, I got an email about titled the Sunshine Task Force Complaint Committee agenda with today's date.
Okay. So you have access to that.
Is there any way of asking what email address those were sent from?
They would have been sent from the San Francisco Public Records email address. I believe it's publicrecords.sfda or sfda.publicrecords@sfgov.org.
Okay, and can you confirm my email?
I'm driving currently, and so I can't, but I responded directly from the email that you sent to our office.
I can just say, because I'm looking at one of the letters, that at the top it has inbox.ovales, OVALLES @gmail.com. That's in the heading of the letter. We don't actually have, a screenshot or, the email header. We just have the letter that was to be sent by email, and that email address is under your name on the header of that letter.
Okay, because if that was sent back in March, I sent an additional email on April 5th, and at no time did I get any response to that saying, hey, we just sent you, responded to your email and at all. So I'm not sure about the responses. Nothing was mailed to me either, but I didn't receive not one of those emails.
Okay. So
if you want to look at them, if you have the packet downloaded, I just want to mention that you can look at them at like P21 through P23 are those responses.
P21 through P23.
So it's not the actual page number, it's the P number at the bottom of the file.
Oh, okay. I've opened the document, but I don't see any P. I just see the link to the agenda PDF.
Oh, you have to hover over your number of your item, and if you hover over that number, you should be able to download the complaint item packet.
You should hover your cursor over the description. Don't just look at the number. Hover it over the summary of the case.
Okay.
And all your records should pop up.
in attachments.
There'll be a cover page that says your file number and what item number it is, which is item number 4.
Okay.
Are you in the attachment?
Yes.
Okay. Now, do you see where it says 21141, item number 4 on the cover page? It has a list of documents with page numbers. And if you just scroll down, you should get to all the items that are in your case.
Okay, I'm scrolling down. Okay. I can see 24 documents, 24 pages.
Mm-hmm. And I think it's page 15 where P21 starts. That's the first of the letters, dated April 2nd.
You said P17? I'm sorry.
No, P21, page 15
Oh.
on the sidebar, or P21 at the bottom of the page. I mean, because the other thing that we haven't really discussed is that the DA's office says that there are no responsive records, and that records that you may be able to get are publicly searchable.
Okay, so if records were transferred from the police department to the district attorney, there would be no record?
Well, they're saying there's no record, no records. Can we ask one question of the respondent? Or I would like to ask, how was the search for these records done?
It was done through our case management system for any records relating to Ms. Ovalis or any of the people that she identified. And I also had many conversations with one of our investigators who has had multiple conversations with Ms. Ovalis, explaining that the incident that she is referring to happened outside of the jurisdiction of San Francisco, and so our office could not prosecute it, and so it would not ever result in a case within our office.
So, Ms. Ovalis, may I ask, what did this incident happen outside of San Francisco?
No, the crime occurred in San Francisco, but I live in Texas, so I reported it in Texas, and it was transferred in San Francisco because Texas said they had no jurisdiction because the crime occurred in San Francisco. And so that's why I submitted my report and my evidence to SVU, Sergeant Creed, who gave me a incident number and told me she escalated it to the district attorney's office back in January of 2021.
Unfortunately, I don't believe that that's true.
What can you tell us what part of San Francisco or where in San Francisco, just to make sure that we have an understanding?
No, it was an incident of my former husband. It was a domestic issue, and so when I tried to report it here, in Texas, I said we don't have jurisdiction because he committed it in San Francisco. And so that's why they did a courtesy report and transferred the case to SVU, and they told me to FedEx my evidence, which I did, and it was processed through Sergeant Andrea Creed, and then she told me she's written it up and she escalated to the district attorney's office.
What neighborhood of San Francisco or what part of San Francisco do you know?
No, I'm not familiar with the areas. I think it's Terraville area, I believe.
Terraville?
Yes. Terraville Station is the area around there, the police station around there.
Okay.
And the whole point is that there's been another crime, and so I was trying to get the assistance of the district attorney of San Francisco. Because that's where the initial one happened, and another crime has occurred since then, but no one has called me back.
And can I ask Ms. Burke, why do you believe it was not in San Francisco?
Sorry, I was on mute. So,
Sorry.
I can't get in. We're limited as to what we can say as it's a report of a crime, but I can tell you that the crime originated with regard to Ms. Ovalis and her husband in custody when they were in Texas. That's how it was explained to me, and that she did not agree with her husband and the way that they were carrying that out. And it has been explained to her multiple times. She keeps saying she never got a phone call back. She's talked to at least 4 different investigators with our office, explaining to her why this is not a case that can be handled at our office and why it was not presented to us by SFPD. for a charging decision.
And I have the email right here in front of me, February 22nd by Andrea Creed. She said that if I'd like a copy of the report, how I could get it, that she submitted my documents to Assistant District Attorney Pearl Tan, who I spoke to at the San Francisco District Attorney's Office. And I did speak to an investigator. I believe her name is Lieutenant Molly Braun, and she was very, I guess, very difficult to talk to, because she started telling me that she would not process my violation, that she was not going to allow it to go forward. And I asked to speak to a supervisor, and I did ask her for a public records request, and she said, I don't care what your evidence is. I'm not going to look at it. I'm just not going to process it. And she even also said she was going to report me for attempting to, and I tried to cite my victim's Bill of Rights as being the victim of this crime, and she would not allow me to present anything to a prosecutor. She just said, no, it's not going anywhere. It's just not. And I had that conversation with her on March 14th of 2021. And I followed up with her because Sergeant Creed had told me my case had been forwarded to the district attorney's office. And I haven't heard anything from their office. I've attempted to call victim services, and they wouldn't assist me. They haven't called me back. But the crime occurred in San Francisco.
Okay, thank you.
Any further questions?
Mm.
I don't have any. So I think we probably could, we could figure out what we're going to do with this. And again, to the parties, this is a complaint committee hearing. We cannot make a final determination on this complaint. I think we understand that the parties have a different view of what's going on here. But what we can basically do is determine if we have jurisdiction over the case, and then we can determine if we want to send it to the full task force. Whether I don't see that there are, records of any kind here, but I don't know. I don't know because again, the parties have a different view of this thing. But if there were such records, then they would be, I think, within our jurisdiction, and they would be public. So that's my understanding. But the DA says they don't have a file on it. That's my understanding, and we just don't know. Member Stein, anything?
Yeah, I just want to say one thing I think would be very useful here for Ms. Burke from the DA's office is that if you can add to this file the messages from your outbox with the timestamp and date on them, that would probably.
I just got home and I forwarded the email that I sent in April with the attachments to Ms. Ovalis again and to Ms. Leger's email.
Okay, great. Then for Cheryl, I want to say, please, I would add that to this file because I think it's important to have that.
And it's not in the file?
I don't believe so. I think what we have is the letters in a PDF form, just the letters themselves, but not that content in an outbox with the email on it. Unless I missed that somehow, but I don't recall it.
I would be willing to forward the email from Sergeant Andrea Creed from San Francisco SVU and the report that she wrote up as well.
Well, if she wrote up a report, isn't that a public document that you have access to?
Yes, but the report would go to the district attorney's office, so they would have they would have the same report and any transmission of how it was sent. And so they're saying they don't have anything, but she replied in an email that she escalated my case to the district attorney's office.
Yeah, that would be helpful.
Okay.
I would make the motion that we find jurisdiction, find that the documents are public, and send this forward to the full task force. And of course, the documents that the parties submit would be useful when the task force looks at this.
Allowed?
We're discussing among the members right now. I'm not sure who that voice was.
I will second that motion.
Okay. In that case, Cheryl, let's go ahead with public comment on the matter.
I just want to be clear about the motion. To find jurisdiction that the records are public and forward to the task force with documents, with public documents that the parties submit, additional documents. Is that what this is?
You could take out the last part. I just wanted the parties to know. Basically, simply, we find jurisdiction, we find the documents would be public, and we send this to the task force.
Okay. All right. Okay.
May I kindly ask what email would I use to submit everything?
It's the email that's provided on the cover page of the agenda.
Okay,
Just submit it there and I'll get it.
thank you.
Sure.
Just to be clear, it is sotf@sfgov.org, just in case there's any confusion. This is Victor Young.
Thank you.
Thank you, Victor Young. And so now we will have anyone who wants to make public comment on this matter when Cheryl.
I'm so sorry.
This
is Robin Burke. Can I ask a clarifying question?
Yeah, that's fine.
So this complaint was made about timeliness of my response and not about the response itself. And so when you're forwarding to the full commission, I'm confused as if you're extending the complaint to include the contents of the response and not just the timeliness matter.
Well, I think that it would include the content because it's Ms. Zavala's position that she received no response. I understand that, we have these 3 letters. And so, there's a factual dispute as to whether they were appropriately emailed back to her. And I can understand that, there is evidence that there will be evidence that they were emailed. And that's understood. But I think that it will still be an issue whether the substance of the letters was appropriate. That we can't say that won't be an issue.
Thank you.
Cheryl, are you ready for public comment? Is there anyone here who wants to make public comment? I should ask.
Yeah.
Anonymous number 3.
Okay, anonymous.
Too.
Okay, I think anonymous 3 spoke second. Who's this other person?
My name is Sergey Severinov.
And you want to make public comment about this case?
Yes.
Okay, so you'll go first when Cheryl's ready.
Okay.
Sir, are you ready to speak?
Yes, I am.
Go ahead.
Okay. As an interested member of the public, I have actually acquainted myself with this complaint. And what I see is the district attorney's office is making mockery of the California Sunshine Ordinance, of the California Browns Act, and the San Francisco Sunshine Ordinance. The fact is, when I looked at the complaint, it was pretty broadly asking for all records relevant to the complainant. In the response, the district attorney said they only searched in their case management software. You know, that's basically the key here. Their answer already reveals that they narrowed the complaint, narrowed the records search to only those which exist in the case management software. So in other words, if there is a case that they're considering for prosecution, they will find it. But if there are any other records, they wouldn't even look for them. But Brown Act and Sunshine Ordinance does not allow this kind of restriction of search to any specific database or any specific software. They should have looked broadly in their email system. They should have looked at all their written documents, which they didn't do. And so basically their response that there are no responsive records is basically meaningless. And let's say at the minimum, it just as I stated from the very beginning, is basically making a mockery of the Sunshine Ordinance and making a mockery of their California's Brown Act. So I think the citizens of San Francisco are sick and tired of the current DA, and this is going to be one more argument why we should recall him in the next year. Thank you.
Okay, thank you. And we have also Anonymous 3. When you're ready, Cheryl.
Are you ready, sir?
I am.
Go ahead.
Thank you very much. This is Anonymous number 3. And essentially all of the last speaker's comment, except for the very last part, I'll express no opinion on the electoral part of it. But everything else he said, completely agree with. As long as you use the word Public Records Act as opposed to Brown Act, but that's exactly right. You have already found the district attorney office in violation for a very similar artificially narrow search violation a few months ago, if I remember correctly. You're responsible for searching all the places that a record might reasonably be. And a transmission from the SFPD to the district attorney's office may reasonably be in email or in some other kind of system, and you need to issue the appropriate searches. And it's possible that if they just take the case number and just do a full back-end search of their email system, they might find a few more records. Now, whether those records are exempt as open investigations or whatever, that is a separate story. But they do need to do a full search, and maybe they'll come up with this communication from the SFPD that this SFPD sergeant claims they sent to the district attorney's office. Of course, maybe it's the SFPD who's wrong. We don't know until they do a full search. But they are responsible for doing that full search. Finally, as a logistic issue, it's possible that the email from the DA's office is getting blocked. There's a system, and this was discussed during the Hooper cases, where if the city's computer system thinks you're sending something that looks like a social security number, it will, even if it's not a social security number, maybe it's like a case number, it will potentially block that email. And so it's possible that it is possible that the DA's office genuinely sent this response and the other person genuinely did not receive it if that kind of thing happened. Thank you.
Thank you. I believe that's the extent of public comment on the matter. So we can have a vote now, Cheryl.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein, to find there is jurisdiction, that the records are public, and to forward the matter to the task force. Item number 5, are we ready for item number 5?
Yes.
Item number 5, file number 20011, complaint filed by Ahimsa Porter Sumchai against Mayor London Breed and the Office of the Mayor for allegedly violating Administrative Code Section 6715, 67.5, 67.6, by failing to have a meeting quorum and failing to conduct business in a proper manner and failing to notice the time and place of the meeting and failing to allow public comment. On October 6, 2021, the task force moved to continue the matter to the call of the chair, pending the results of research by the deputy city attorney and the committee review to be determined by the chair prior to additional task force hearings.
All right, thank you. So this matter, it has been before the task force, and there was an issue, a legal issue about whether the body involved is a policy body. And so with that as a question to be determined, we got this referred to us as the complaint committee by the chair, I guess, to figure out what to do with it. I don't know. I don't think, Member Stein, tell me if you think differently, but I don't think we need to hear from the parties because there's nothing new that we haven't heard already at a prior committee hearing at the task force. This is simply the determination on the legal issue in terms of what we know now, what we may know later. Any ideas on what you would like to do with this, Member Stein? I'm open.
With hearing from the parties or with the case?
Either.
I feel like if the parties are here and they want to speak to this question of jurisdiction and what the city attorney's office had to say, that might be appropriate. It does seem that, the question was really, is this a policy body under the San Francisco city and county, right? And basically the determination was that it's not.
I'm gonna interrupt at that point. Correct me if, Cheryl, correct me if I'm wrong, but anything that there is not anything that is available to the public that I know of that the city attorney sent out to the public. If
I'll tell you,
if there was attorney-client advice, if there was advice from the city attorney's office, and I'm not saying whether there was or wasn't, that's, as far as I know, it's not in. It hasn't been published to the public. Cheryl, am I correct about that?
You are correct. The task force has received city attorney advice. It is confidential. It has not been disclosed to the public. I still have it in my file.
Yeah. So any information that would come that way is not in the file.
Okay.
And so, in terms of like what we're doing here today as a committee, I don't know if we have that many options, because I think we pretty much, we can't, I don't know if we really could make the case go away. I think that that would have to go to that would have to be done by the task force, or to have any other kind of resolution. I think it would have to be done by the full task force. In terms of, whatever happens with any kind of legal advice, we as a committee certainly couldn't waive privilege, and I'm not suggesting that anyone waive. But I think that it may be, I'm not quite sure, frankly, why this would even be sent to our committee, because I can't see any other option other than just sending it to the task force. But it sounds like Member Stein did say that she would like to hear from the parties. Would it be okay with you, Member Stein, if we heard from? They can't respond to something that
Okay, I got
they
it.
don't know about. So I don't. Do you still want to do that?
No, I mean, I don't think it's necessary then.
Okay. Okay.
Just to let you both know that this matter will be heard before the task force in January.
It
So then I'm
will.
curious,
It's already scheduled.
For January.
then I wonder
for the
why.
task.
I thought it.
Why is it here?
Yeah.
I think to air out whatever grievances parties have, so that the task force can be fully informed on this matter.
I think.
I know the respondents submitted new information.
I'm sorry, but that doesn't make any sense to me. I'm going to move that this matter be sent to the task force, since it's already going to the task force, and that it be set for hearing. That's my motion.
Okay, I'll second it.
And so we can have public comment on it.
I'd like, as a member of the public, if you are censoring my input into a matter I filed as a complainant, I don't think.
Well, we can't hear from the parties. Well, I guess we could let you make public comments, since you.
Yes, you can, and
But
you also.
No. Miss Dr. Sumchai, wait for Cheryl to start her timer, and then we'll let you. I'm going to let you make public comment as a courtesy.
Can I also ask, though, that if there is, if complainants or respondents are making public comment, that they address any new information that may have been submitted, because we have heard comments on this at least twice already. We've heard from both parties. So I just want to throw that out there. It would be most helpful if it was have something to do with anything new in this file.
Absolutely, and you're certainly not required to give public comment, but you may. I'm going to give you, Dr. Sumchai, an opportunity up to 3 minutes for public comment. Anyone else, in addition to Dr. Sumchai, who wants to make public comment on this matter?
Yes, Elise Vincent here, part of the respondent. I would like to make public comment.
Just a moment. Why are we putting Dr. Sumchai under public comment? She should be making a statement on her own accord, not under public comment.
Well, we did not ask her to speak on the case. Cheryl, do you think we should not be allowing her, because of the rules, to make public comment?
I think she should be allowed to make her comment, not under public comment, but as an opportunity to speak on her case.
I'm fine with that. If the parties want to speak, I'm fine.
That's fine. That's fine. Let's then let her make a 3-minute public comment as a matter of courtesy of the chair, and then we will move on to the public comment after that. So we're not doing public comment yet. Yes, Cheryl, whenever you're ready, when your timer, we'll let Dr. Sumchai speak.
Dr. Sumchai, are you ready to begin?
Yes.
Go ahead, Doctor.
Dr. Himsa Porter-Sumchai, I've made my introductions in the past that available to the public, part of the record. I first want to identify that in file number 20011, under attachments, that it is the only file in which the attachments cannot be accessed. I've attempted to access them on both a Google and a Safari search site, and the attachments don't light up and they don't open up. With regard to the new information, I strongly object that the city attorney has a right to an opinion under the Sunshine Act that I'm not privy to. I believe that the city attorney has no legal right to make an opinion that is confidential. In fact, I see no reason why city attorney's opinion in this matter would be confidential, and I expect to receive a copy of the city attorney's decision in this matter before it goes to the full task force meeting. The second issue I want to bring up is under hearing on the complaint. It says item 5, part 1 through part 6, and that is absolutely unclear to me why you have designated 6 different issues for discussion and action on the complaint. Final statement that I want to make is the issue of basic courtesy and civility. If you were planning to depart from the normal agenda and not allow complainants or respondents to speak, I would have appreciated that. I do operate 3 medical practices and start my day at 7 a.m., so this is a professional encroachment on me. And you certainly should be aware that there is a Superior Court civil grand jury investigation that has looked at the Sunshine Task Force approach to this matter. I strongly believe that my constitutional rights to freedom of speech have been violated, and I have great concern about biased actions that the task force has taken on behalf of the mayor's office and the mayor's Hunters Point community advisory.
Dr. Sumter, your time is up.
Okay, thank you. Thank you. So now we can move on to public comment.
No, I'm sorry. I'm the respondent, and I would like to make a statement as well.
All right, that's equitable. So we were not going to public comment yet. Let's go ahead and when Cheryl's ready. Could you identify yourself?
Excuse me, Chair Schmidt, before we go on any further, I just would like to address Dr. Sumchai's statement that she was unable to retrieve any of the documents.
Yes.
The 6 different parts were all identified as such because her case has over 1,100 pages. And I could not, it's impossible with the program we have, to have an 1,100-page compilation of records be included in the agenda. Packets can only be so large. It can only take so much space. And so I had to divide her case into 6 different parts so that it could be properly uploaded to the web page. That's the only reason I did it. And I had to highlight, when you hover over those different parts, you will see the records that have been included for this complaint. I just wanted her to understand that first.
Yes, that there are 6 parts because those 6 parts contain all the records of the case, and they're accessible not at the word attachments, but at the 6 different parts. Yes.
Correct.
Okay. Thank you, Cheryl.
Can I just ask Cheryl? Oh, can I ask Cheryl quickly? Does it say, I can't remember, like in the heading to the documents that you need to hover over the paragraphs to access the documents? Because this is the second party we've had that didn't realize that.
What it says in the email is I have to look at the email now. I think what it says is, the first sentence is, this is the agenda packet for the committee, the date, the time of the hearing. Then there is the link to the agenda packet, and then below that it says hover over information. So
okay,
okay, is that clear to everyone now?
Just checking. I wanted to see if we needed to be more clear, but I guess it's there.
All right.
And if Dr. Sumchai has difficulty accessing the records in the future, she's more than welcome to email me, and I'd be happy to walk her through it.
Okay, great. So then next we will, when Cheryl's ready, we'll hear from the respondent. And could I just get your name, please?
Elise Vincent.
All right, thank you.
Are you ready, ma'am?
Yes.
Go ahead.
Okay, thank you. So I wanted to say thank you to the task force for allowing me this time to speak. There's nothing new to add. I would just point out that we have been, my organization, between Micah and myself, Micah Fobbs and myself, has been to the task force on these same issues now 6 times. 4 in the full task force meeting, twice now at the complaint board. At each of those, the first 2 cases, the cases were totally, the resolution was that they didn't find a violation, it was done. She didn't ask for reconsideration. We went through that again for 2 different meetings. And at the last 2 meetings, the resolution, especially the last one, if I'm not mistaken, was that the chair recommended that based off the district attorney, deputy attorneys, I don't know, whatever attorney, I'm sorry, so I don't want to say the wrong thing. Whatever attorney was supposed to give you the legal feedback on whether or not we were a passive active body or a policy active body. I thought that the recommendation was, based off that information, if we were found not to be a policy-making body, then there is no violation and it's a moot point. If we are, in fact, being seen as a policy-making body, then you guys can rehear the case under those terms. Because it's confidential, I won't get into, even though we all know, what the attorney said about the legality of the issue. However, why are we still being scheduled to come back in January? This is going to be now the 7th meeting that we've had to come before you all. And if you all work talking amongst yourselves in that confidential letter that says, hey, this is what it is, unless the district attorney is saying they are a policy-making body, I don't understand why we have to come back in January. Thank you.
Thank you. Okay, now we can go to public comment. Is there anyone here who wants to make public comment on this matter?
Chair Smith, before you begin, I'd like to maybe make a suggestion.
Sure.
That we contact Chair Wolf to make the January hearing a hearing to determine whether or not to release the confidential memo, because the parties will not be able to see it until we make that finding on whether or not to release the city attorney findings. It's just a suggestion that maybe we should.
Victor, do you want to release it? Is that what you're saying, or do you think we want to release it?
Only the task force can determine whether or not to waive confidentiality, and maybe we should make that finding and distribute if they do release or waive confidentiality before we schedule them to come back or schedule the parties to return.
Well, I appreciate the suggestion, Victor. Let me talk to Member Stein about your suggestion. What do you have any thoughts, Member Stein, on that?
Yeah, I mean, I would support waiving confidentiality on it. I think it's an analysis that everybody should understand, like in terms of why we might make a determination of whether we have jurisdiction or not. I don't see the harm in releasing it. And I think it would be important for the parties and the public to understand, how we are evaluating the question of jurisdiction.
Okay. Let me just then say, based on Member Stein's interest in the potential waiver of privilege, that means we will have at least one member who, and there probably, there's a good chance there'd be others who would wish to waive. I would recommend we do follow what Victor recommended, and we change our determination to say that this is going to be sent to the task force to consider the possibility of disclosing any kind of attorney-client or any kind of advice from the city attorney's office on this matter to the public. And so, but it will be sent on, and that will be considered at that time. Whether we also consider the case at that time, I think we should leave that determination until the task force hearing, whether to just consider the waiver issue or whether to consider both the waiver issue and the case in itself at the same time. So basically, the motion that I will make to substitute, and I withdraw the prior motion, is move to send this to the task force to consider possibly disclosing any advice from the city attorney's office to the public, and potentially for consideration of the matter at that hearing also.
Can I say one problem I see with that?
Yeah, sure.
Just that if we do waive it, then I don't know, basically I want to say I read the city attorney's memo and then I did a deep dive because I wanted to understand what was the analysis that was there, and I kind of did a deep dive into this question of jurisdiction, looking at all kinds of documents I hadn't looked at before. And I feel like if the parties want to be able to argue something different or respond to that it's just would be very hard for them to do on the spot.
You talk about the legal question of policy body, just to
really I want to say it's the question of whether we do have jurisdiction here. Yeah.
Jurisdiction over the Hunters Point body, correct?
Correct.
Okay. Well, I'm going to withdraw my motion, and I will.
I would support going to the SOTF to release, to see if we can have a waiver for this document. But I'm just not sure that we should then also be addressing this case in the same moment. And I don't think the parties would need to be there for that, because it's just a question of, do we want to waive the confidentiality of this document?
Okay.
Member Stein, I wouldn't advise that.
No?
No, I would not advise saying the parties don't need to be present.
All right. Then I take that back.
How about if we let me try to phrase a motion again. Move to send this to the full task force for consideration of the case, which may which may include whether to disclose any advice from the city attorney's office to the public.
I'll second that.
Okay, so now we can move to public comment. Is there anyone who would like to make public comment on this matter?
Anonymous number 3.
Sullivan.
Okay, we have anonymous number 3, I heard first. Sullivan, second. So when you're ready, Cheryl.
Anonymous, are you ready?
Yes, I am.
Go ahead, sir.
Thank you very much. This is anonymous number 3. A few comments. I think you could revise the motion to say to ask the chair of SOTF to agendize a motion to consider possible waiver of any deputy city attorney advice in this file for January, and then have the case be considered in February. That makes it very clear, and then you don't have the potential problems that Member Stein said, and anybody can show up whenever they want to show up then. But as to the actual issue, first of all, as always, just because your deputy city attorney says something doesn't mean the SOTF rules that way. As you have not done so many prior cases, and you're not obligated to do so. That's why the SOTF is an independent body of volunteers, and the city attorney is, well, the city attorney. And the biases inherent to that have been discussed in one of your other committees. But you know, David Chu may be right here. I'm not saying anything about the substance of that. Just as a general matter, you're not bound to do whatever David Chu tells you to do. And the other issue here is I thought the same. My memory was the same as what the respondent said as to the issue that what about whether it's a passive meeting body? Because just because it's not a policy body, which is not necessarily about whether any policies are made, but it's just a definition in law about how how a body was created. And the same thing is about a passive meeting body. It's about how the body was created. And so just because it's not an SF policy body doesn't mean it's not necessarily or even if the city attorney doesn't think it's a policy body, doesn't mean it's not a passive meeting body. And I thought that the whole point was to consider that question. That was what the advice memo was supposed to be about. But I guess none of us really know what the full extent, or none of us in the public know what the full extent of the memo is. So I would strongly urge that the full task force waive the attorney-client privilege and publish the document. It is still an open question. Was the memo addressed to the complaint committee or the full SOTF? Because my understanding is that would affect who actually has to make the motion to waive the privilege. And that's it. Thank you.
Okay, thank you. And when you're ready, Cheryl, we can hear from Sullivan.
Mr. Sullivan, are you?
Yes.
Okay. Go ahead, sir.
Okay, in the respondent's comments, it sounded like she has seen this memo. And I don't know whether it's the memo says it's passive meeting body or policy body or something other. If it's something other and she's seen the memo, then there's no attorney-client privilege anymore because there's a public person that has seen that memo or any other memo. And it's even questionable. I mean, I know that the city attorney's office will defend the Sunshine Ordinance Task Force, but one thing is that you guys are not employees. So it's like you're not employees of the San Francisco city or county. And so it's a question as to whether you are, whether they should be sharing it with you and not with the rest of the public. So the other thing that I wanted to say is on the agenda, you don't hover over it. You have to actually click to put up the agenda, to get the agenda item. If you just hover over the thing, all you do is get a little box, information box that says where the link is.
Anyway, that's it. Thank you for your time.
All right, thank you. So I think we're ready for a vote, Cheryl.
Public comment, please.
Oh, we have another public commenter. When you're ready, Cheryl.
Mr. Warfield, are you ready?
Yes. Just let me know when to start.
Go ahead.
This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California 94117-0544. I want to make it clear we are not a party to this. We're not particularly familiar except to know that this has had a long and tortured career at the Sunshine Task Force. And not all of it has been for the straightforward reasons one would hope. So the first thing I'd like to say is that Member Stein makes a lot of sense, and I think the motion is flawed because it suggests that the question of revealing the contents of legal advice to the task force is going to happen at the same time as the possibility of a hearing. And I don't think that it would be fair to the complainant on a matter that has to do with open government to keep secret something and then only reveal it at the very moment that the hearing is supposed to move forward. Perhaps Dr. Sumchai would like to consult an attorney. Maybe she'd like to review the law, just as Member Stein said she would like to do, or might like to do. So I think that Member Stein, and I would agree with anonymous number 3, her motion would be, if you want to consider the confidentiality question, do that as a separate step so that whatever the response is, Dr. Sumchai could respond to that in a fully informed way. So you've had 2 excellent public commenters. I also have known Dr. Sumchai as having brought many very civic-minded matters to the Sunshine Task Force, and she should be given every opportunity to be fully informed about what's happening, as should anybody. I want to say that I'm horrified that we would have an administrator interrupting to basically try and shut down or in some way infringe public comment or anything that the chair would like that's basically fair. The minimums required by law don't bind you to stick to just the minimum. You can do more if you like. As for hovering over, and whether that's in some hidden email, I have a print version of this, and there's no indication that there's anything attached that one can get to or how to get to it. And I think it's totally wrong to not indicate exactly where things are and how to get to them when there might be people using print. Thanks very much.
Do we have other public commenters? Chair Schmidt, I think you're muted.
I'm sorry. Thank you. I was muted. So yeah, I think we're ready for a vote.
You want to repeat the motion?
Yeah, I will. Moved by Chair Schmidt, seconded by Member Stein, to move to send the matter to the task force for consideration of the case, which may include whether to disclose advice from our deputy city attorney to the public. Chair Schmidt, did I get that right?
Yes.
All right. Let's do the roll call. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. I will repeat it again. Moved by Chair Schmidt, seconded by Member Stein, to send the matter to the full task force for consideration of the case, which may include whether to disclose advice from our deputy city attorneys to the public.
Okay. We can, when you're ready, Cheryl, we can move to the next item, which would be line number 6.
Item number 6, file number 21148, complaint filed by Jordan Zentaga, I can't pronounce his name, I'm terribly sorry, and Carl Kramer against the San Francisco Employees Retirement System for allegedly violating Administrative Code Section 6721, 6724, and 6725, and the California Public Records Act, Section 6254.26, by failing to respond to a request for public records in a timely and or complete manner.
Okay, and in this matter, let me see which parties are present. Is either Mr. Santagatas, I hope I pronounced that correctly, or Mr. Kramer available?
I'm here. This is Carl Kramer.
Okay, great. And anyone here for the SF Employees Retirement System?
I'm here, Jay Hewish, Executive Director of the Retirement System.
Okay, great. And so in this matter, I would like to open this up for each of the parties to speak to the matter. We have your, all the paperwork we've reviewed. And so I'll give you up to 5 minutes each to speak about the case. And so when you're ready, Cheryl.
Chair Schmidt, you've been allowing people 3 minutes to make comment.
I think it's been variable. I would like to do 3 minutes. Member Stein, do you think 3 minutes is going to be sufficient?
I think I think the documents are pretty clear, so.
Okay.
Yeah.
Thank you. 3 minutes each party, please.
Okay. Is the petitioner ready to speak? Hello?
Hi. Are you able to hear me, Cheryl?
Yeah, I am. Are you ready to speak, sir?
I am.
Go ahead.
All right. So you'll see on page 742 to 743 the initial request for information that was sent by Jordan Santagata. It's she, her. And then on page 742, response on October 7th that the document is not subject to public disclosure, and then you see on page 751 kind of the legal question that we were seeking an answer, and I believe that's why it was referred to this committee. So the Jordan looked at the language of the Sunshine Ordinance and didn't find any comparable exemption from disclosure in the Sunshine Ordinance. So our question is whether the Public Records Act preempts the Sunshine Ordinance in areas where the Sunshine Ordinance could be broader in what's required for disclosure.
Okay, thank you. Now we can hear from the respondent.
Committee members, thank you for your time. Again, Jay Hewish, Executive.
I'm sorry, but we need to allow Cheryl to start her timer.
I'm sorry.
And then you can proceed. That's understandable.
I'm sorry, sir. I didn't get your name.
Jay Hewish, H-U-I-S-H.
All right. Are you ready to begin?
I am.
Go ahead, sir.
Again, thanks the committee for their time. We received this request on October 5th, and we timely responded on October 7th. They're requesting contract for our relationship with Vista Equity Partners. The retirement system holds Vista Equity Partners as an alternative investment in the SFR's portfolio. We have our investment relationship with Vista Equity Partners is as a limited partner. And we believe that the California Public Records Act, Section 6254.26, provides a very specific carve-out for protection from public disclosure of these types of very business confidential documents, and that it basically states that notwithstanding any provision of the California Public Records Act or other law, records related to alternative investment agreements shall not be subject to disclosure pursuant to this chapter unless the information has already been publicly released by the keeper of the information. And I'm here to certify that we have not in the past released this information related to Vista Equity Partners or any of our other alternative investment partners publicly. And with that, I'll be happy to answer any questions that the committee may have.
Thank you. So now is the time for any kind of questions. And Member Stein, do you have any questions for either of the parties?
I don't think so.
Okay, I'll go ahead with. I do have a question to start with for the respondent. In considering section 6254.26, you read us 6254.26A. Did you consider section 6254.26B when you responded to this request?
I did not believe that we have publicly released the information related to section B, and that has been at a public meeting. I believe it was at the June 2021 board meeting, if not the June, the July. And so we have provided that as a public record, but we did not think that that was responsive to the request, because the request specifically was for past or current contracts between the city and county, well, actually the city of San Francisco and Vista Equity Partners.
Okay, so you're saying you have already published to the public what would be within the scope of subsection B, correct?
To the extent that we are required at the time that it is approved by the board, we've released the name, the dollar amount, the cash contributions, and we've announced that in fact we've entered into the agreement.
Okay. In moving to the complainant, that information that has been disclosed under subsection B, is that something that you have received at any time?
No, we didn't receive that.
Okay, and you did not receive that in response to this request, correct?
That's correct.
Okay. I assume you would be interested in seeing that information, correct?
Correct.
Okay, thank you. All right, so, well, I will say that this is not a decision. This is just an observation. I would guess that Mr. Kramer would, I think subsection B should be read pretty closely with subsection A. So I think Mr. Kramer would like to get that information. I don't know if Mr. Kramer knows exactly where you published that publicly, but he did make a request. So I think that's probably something he's entitled to hear.
Yes, I will. Oh, I'm sorry.
Oh, go ahead. Go ahead.
I was going to say this is a relatively new investment with the retirement system. In fact, I believe it is vintage June of 2021. So a lot of the detailed information in subsection B is not available because it's a very new relationship. But certainly I'll be happy to provide the public notice of the investment and the details that were provided to the public to Mr. Kramer.
That would be appreciated. That might just that would at least make some issues go away here. I know there's a question as to whether the state law or the local law is the determining law here. And that's a question that has been specifically been asked by Mr. Kramer. Yeah, that's an issue in the case. I don't think I have any other further questions for the parties. Member Stein, anything come to mind? No? Okay. So we can then consider what we would want to do with this case. And again, reminding everyone that this is a complaint committee, and so we can't make a final determination. We can, however, decide whether we want to send this to the full task force. I think it would help, and it doesn't sound like this is going to be a problem, to have those documents sent over to Mr. Kramer, because that may be all Mr. Kramer wants. I don't know. I think it's a good question, and again, this is the part the members are sort of discussing and talking about your case. I think it's a good question whether, possibly the Sunshine Ordinance here trumps the state law. My initial thought is actually in my personal legal, my sense legally is this looks like it's pretty clearly established as a matter of state law. And yet, state law is specific with subsection A and subsection B. And so my thought is, well, we pretty much ought to be sending this on to the full task force to look at the legal issue, because we can't make the call here. Any thoughts otherwise on this?
I don't know. My only thought is that there are sections in the Sunshine Ordinance that seem to take for granted that it doesn't override specific exemptions in the California Public Records Act. And that's my reading of it. And maybe I'm reading between the lines a little bit, but there's just a couple places where it suggests that we don't get to just override those exemptions. That's my perspective. If you still think it needs to go to the task force to address that, I'm happy for it to go there.
Well, I think that I think you and I are in agreement that this, at least from our perspective, yeah, this is a state law. Probably the state law governs, and I don't think the Sunshine Ordinance purports to override this kind of state law exemption. Yeah, I guess I feel like our hands are tied as to what we do. If the party, if the complainant wants her case heard, we simply have to move it on. I don't think we can stop it. And so that's, do you have, Member Stein, do you have a suggestion as to what else you think we should do with this matter?
No, I mean, we might want to cite a couple sections in the Sunshine Ordinance that seem to speak to this question of, you know, the CPRA's relationship to the Sunshine Ordinance.
Sure.
But you know, so I was going to say, I feel like section 67.21, which addresses the process for gaining access to public records and administrative appeals. Section K, so it's 67, sorry, I'm scrolling up and down here, 67.21K says the release of documentary public information, whether for inspection of the original or by providing a copy, shall be governed by the California Public Records Act. In particular, is not addressed by this ordinance and in accordance with enhanced disclosure requirements. And then, let's see. There was another section which actually where it's talking about immediacy of response. I think 67.25. Wait, is that right? C, it talks about where a record being requested contains information, most of which is exempt from disclosure under the CPRA. You know, so there's just there's that piece. Yeah, I think those two sections, for instance, it's, you know, it's not, it just seems to suggest that, you know, we can't override the exemptions of the CPRA.
So it sounds like you want to make a motion to move it forward with a recommendation. Is that what you're thinking?
I was just to highlight those sections, for instance, so people just know where to look to begin to think about. Well, I mean, it's two places to look to think about the question.
Well, I'd probably, it sounds like, go ahead and make a motion. See if you can compact that, and I'll second the motion.
That we move this forward to the task force to address the question of whether anything in the Sunshine Ordinance might override specific exemptions in the California Public Records Act. Maybe just leave it at that. People can look at, I can't go back and find these again. So
I think you were talking about 6721K and 6721C. Is that what you meant?
Yeah, so the task force might want to turn its attention to those two sections, for instance, to think about this question.
And should review them? Is that what you want to say?
Yeah, sure.
You got that, Cheryl? I'll second that.
All right, let me just make sure I got it right. Moved by Member Stein, seconded by Chair Schmidt, to move the matter forward to the task force and address whether anything in the ordinance might override exemptions in the California Public Records Act, and to review Administrative Code Sunshine Ordinance Section 6721K regarding the inability to release certain public information of the Public Records Act, and 6721C. Am I getting it right?
Sorry, this is the problem. Is that I don't have this in my notes and I'm having to scroll around to find this. So 6725C.
25C, okay.
67.25C.
Right, and that would be
These are just two places that address.
having to do with the immediacy of responding to the request.
Mhm. I mean, these are two places where the Sunshine Ordinance seems to assume that we can't override the exemptions of the CPRA, which is why I cite those.
Okay.
And just to comment, in addition to the ordinance having those acknowledgments, the legal issue would also be something that's this, you know, the state law has impact on the actual law of the state.
Mm-hmm.
So whenever you're ready, Cheryl, we can hear public comment on this matter.
Okay, I just want to get my notes squared away in a minute. Sorry, this is just taking me a minute. So we want to open up to public comment?
Yes.
Do we have public commenters on the motion?
Anonymous number 3.
Sullivan.
Anonymous 3, Sullivan. Whenever you're ready, Cheryl, we'll start with Anonymous 3.
Are you ready, sir?
I am.
Go ahead.
Thank you very much. This is Anonymous number 3. My reading of this, it seems to agree with the two members of this committee. It seems very clear in 26A that it says, notwithstanding any other law, this information shall not be subject to disclosure. And so it doesn't really matter what the Sunshine Ordinance says. In this case, however, the Sunshine Ordinance doesn't even have one of those exceptions to an exemption like it has in 6724 for a lot of other things. And so it seems like it's pretty clear that A does apply and that information is not subject to disclosure. That's different, for example, there's a lot of exemptions in the PRA that don't say shall not be disclosed. It says a local agency may choose not to disclose. And those are the ones that have exceptions to the exemption in 67.24. In this case, I don't think there's anything in the Sunshine Ordinance about alternative investments anyway. But I think the most important issue here was raised by the chair in the beginning, which is that the state law is very clear that you have to disclose these very tiny, 9 items. And so there was a violation here. The violation is of Admin Code 67.26, which is unless 100% of a document is exempt, you must produce all of the non-exempt portions. And, I've signed LP agreements before. There's generally like an addendum where you say how much you're contributing, has the address of the parties and stuff like that. Those parts, 99.9% of that LP agreement or subscription agreement may be exempt, but the portions that are the name, address, and vintage year of each alternative investment vehicle and all these other things, those should be not redacted and they should be produced. And that's exactly what state law says. It doesn't matter how new it is. If any of that information, B1 through 9, is on that document that existed at the time of the request, every other part of the document should have been redacted, and those portions should have been unredacted and produced according to Admin Code 67.26 and state law in subsection B. And then also, there's another part of the Sunshine Ordinance that does instruct agencies, I can't tell you off the top of my head, that if the vast majority of the record is exempt, that you suggest other records that they might look for that might serve the intent and purpose. And I think the chair was also getting to that. It's possible to contract. Sorry?
30 seconds.
Okay, it's possible the contract is 99.9% exempt with only a few things unredacted, but maybe there are these other slides or public notices that they should assist the requester in receiving. Thank you.
Thank you. Okay, we have one more public commenter. Whenever you're ready, Cheryl.
Mr. Sullivan, are you ready?
Yes.
Go ahead, sir.
The California Public Records Act 6253E says, except as otherwise prohibited by law, a state or local agency may adopt requirements for itself that allow for faster, more efficient, or greater access to public records than prescribed by the minimum standards set forth in this chapter, which is the California Public Records Act. So basically that allows for the Sunshine Ordinance to exist and to allow for greater access to records than prescribed by the minimum standards set forth in this chapter. I don't know exactly what he's calling exempt and all that. I was eating, so I wasn't following. And as far as what Anonymous 3 was talking about was 6721C, a custodian of any public records and not in possession of the record shall assist a requester in directing a request to the proper officer, staff, work person, or if it's available, or available in other ways. All right. Thank you for your time.
Thank you. All right. So we can have a vote when you're ready.
Additional public comment, please.
Oh, okay. There is a third now. Whenever you're ready, Cheryl, there's a third public commenter.
Yeah, Mr. Warfield, are you ready?
Just let me know when to start.
Go ahead.
Thank you. Peter Warfield, Executive Director, Library Users Association, Library Users, 2004 at yahoo.com, and also P.O. Box 170544, San Francisco, California, 94117-0544. I'd like to commend the maker of the motion for the motion. It also sounds like a larger potential discussion, which I think would be very useful with respect to what can the Sunshine Task Force override, or what does the law provide for you to allow overriding what the state law says. In any case, I think that the full task force has to decide whether, for example, the categorization of information is appropriate for either exemption or non-exemption. And of course, there are quite a number of places in which the Sunshine Task Force does override state law, and where state law, as previous commenters have said, specifically enables that. So, for example, weighing the public good, that's not something that the Sunshine Task Force endorses as a reason for withholding. Speed of response, for example, the Sunshine Ordinance allows, for example, immediate disclosure requests. So there's quite a bit to discuss here. And the general conversation, I think, would be useful as well. So I think it would be a healthy thing and a good thing to go forward with the motion, and keeping in mind all that the previous commenters have also said. Thank you.
Thank you. I believe that's all of the public comment on this item. And so now we can vote.
Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Stein, seconded by Chair Schmidt, for this Sunshine Task Force to address whether anything in the ordinance might override exemptions in the California Public Records Act, and to review Administrative Code Section 6721K regarding the inability to release public information, and CPRA No. Administrative Code Section 6725C for violating the immediacy in responding to the request. Did I miss anything?
I don't think so.
Sounds good. And so when you're ready, Cheryl, we'll move to the next item. And I think what we ought to do is plan to take a break after that.
Sounds good.
Item number 7, file number 21151, complaint filed by Jerry Dratler against Rich Hills, Shunbori San, and the Planning Department for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner.
Okay, so let's see who's here. Is the complainant here, Mr. Dratler?
I'm here, thank you.
Okay, great. And is there somebody here to speak on behalf of planning?
Yes, Laura Lynch, Planning Department.
All right,
staff is here.
great, thanks. So we will start with allow you to make statements about the matter. Up to 3 minutes, although we also have reviewed the documents, and so we're already familiar with the documentation in the matter. And after your presentations, we may have questions for you. So when Cheryl's ready, first we'll hear from the complainant.
Mr. Dratler, are you ready?
I am, thank you.
Go ahead, sir.
An article in Mission Local discussed irregularities in the construction of a new house at 365 Pacheco Street. The house is owned by Angus McCarthy, president of the San Francisco Building Inspection Commission. The San Francisco Board of Supervisors will be holding a hearing in 2022 to review the project. I used the Planning Department Property Information Map, the PIM, to look for a planning application for 365 Pacheco Street and was surprised to find there was no Planning Department application in the PIM. This led me to submit a California public document request for the entire project file. The Planning Department's response to my document request was to claim they have a file for a lot merger of the two lots, which was not approved, and there is no construction file. I knew the Planning Department's response was incorrect because the building permit tab in the PIM shows a building permit for construction of the house with a note that a 311 notice was sent to the neighbors. When I informed the Planning Department of the 311 notice, the Planning Department only sent me the 311 materials. I did not receive the entire contents of the new construction file, nor was I told the Planning Department was withholding documents. The Planning Department file should include at least these two documents: a residential design team analysis and an environmental review of the project. And these documents would not be attorney-client privilege documents. The 311 plans the Planning Department sent me did not include pages A2, A3, and A4. Three important issues are before the Sunshine Ordinance Task Force. The Planning Department clearly violated the California Public Document Request Act when it failed to notify me within 10 days they were withholding documents. And then the Planning Department definitely appears to have redacted 3 pages from the 311 plans. It is unlikely the document in the file was missing those 3 pages. And lastly, are all the documents currently withheld by the Planning Department protected by attorney-client privilege? It's unlikely all of them are, and I believe the planning department is misusing the attorney-client privilege to hide incriminating documents. The planning department claim would be more credible if there was a list of withheld documents signed by a deputy city attorney. I'm asking the Sunshine Ordinance Task Force to review the withheld documents. Thank you.
Thank you. Okay, now it's the respondent's turn when Cheryl's ready.
Laura Lynch,
Yes,
are you ready to begin?
I am.
Go ahead, ma'am.
Thank you. Good evening. I was mentioned in my memo dated November 30th, 2021. I'm not going to go into the detail because you mentioned you already did review the files. We did get a record request for a planning application dated October 11th, 2021. On October 12th, the subdivision application was provided because that was the only planning application we had on file. On October 13th, the complainant clarified that he was looking for a building permit application. And later that day, we provided the 311 notification materials, which include plans and the actual notice that went out. We aren't withholding any plans. We are providing all the plans we have. And the complainant mentions the environmental analysis. I responded explaining that oftentimes new construction, just building permit plans that don't require a planning department official application receive the environmental clearance on the actual permit and final plans. So this was typically documented by stamping the final plans or the permit. And so therefore planning would not have that documentation, and the Department of Building Inspection would be the appropriate party to contact. On a number of occasions, we have notified the complainant that we have provided everything we have and that they need to contact the Department of Building Inspection for the final plan. This concludes my presentation. We responded in a timely manner. Later on, we realized more recent emails have been sent that are attorney-client privilege, but those are outside the scope of the original new construction of the property and were properly identified. Thank you.
Thank you. Okay, time for any questions of the parties. Member Stein.
I have a question for the petitioner, which is, did you try to get some of these records from the Department of Building Inspection as suggested?
Yes. A point of clarification. The plans that I wanted were the plans that were sent to the neighbors, and those aren't plans that are held by the Department of Building Inspection. They hold the plans once the project has been approved. Different set of plans.
Okay. And for the planning department, how long do you retain, or for Ms. Lynch, how long do you retain records of building plans?
So we do have a robust record retention policy that we do follow. We typically attempt to keep the 311 plans and official notices that go out by the planning department indefinitely. That being said, this is from 2005, and the planner who originally worked on this project is no longer with the department. From my understanding, these may be the complete plans that were sent to the neighbors. I do not know. We are not withholding. We don't have any other sheets as referenced by the complainant. If we had them, we would absolutely release them.
Okay, that's all for me, I think.
All right. I have a question for the complainant. There was a Barclay email that I think you asked for, and I think that it also referenced some attachments. Did you get the Barclay email, and did you get the attachments?
First, I'd like to say that I didn't request that. So they sent me a file for a lot merger, which I never requested. But when I reviewed that file, I saw the Barclay email, and I never got the 3 attachments. But also, I'd like to say that in the 113 pages they submitted, almost all of the pages are for the lot merger. So what that means, of course, is there were no other documents in the new construction file other than the 311 notice, which makes no sense. This was a complicated project. It's a house that sits on 2 lots, which is illegal, and there's a 20-foot difference in height between the beginning and the end of the lot. So it's really illogical. There are no other documents in that file.
Now, with the Barclay email, you asked for the 3 attachments, is that correct?
Oh, I didn't ask for them.
You didn't ask for them, okay.
I didn't ask for the Barclay letter, but if there were attachments, they should have been sent. Again, it's editing what
you
they
didn't
sent
receive
me.
those, correct?
No, I did not.
Okay. I'll ask the respondent, do you have any information about whether the 3 attachments that are referred to in the Barclay email are available to be produced?
They are not. We do not have them. I've looked everywhere. So
okay.
That was on Lotus Notes. We even tried to go and look through the backup. It's just something we do not have. Again, we would absolutely produce it. That wouldn't be any sort of attorney-client privilege on that. We would have sent that to the complainant if we had it. And I would like to add that I know it's being brought up that we sent the subdivision files over. We also sent them the address file over, which is our historic file that we have of various miscellaneous permits that are tied to an address, just out of an abundance of caution, and also because the complainant was very interested in this property. We wanted to be as transparent as possible, saying that we have provided everything in our possession related to this particular address. So we provided more than we were requested of, and we're not withholding any additional plan sheets from the 311 notice.
Okay, thank you. And there's one other thing I want to ask you about. In our file, and I have it at P794. There's, and it may be elsewhere in the file too, but there's a reference to PaperVision. And PaperVision is a software, and I'm just reading from what I'm seeing. It's a software that select members of the planning department have access to. Is this something where the planning department is able to, do they have to make requests to the DBI specifically for items on PaperVision, or is it something that is accessible to planning departments where they can go into PaperVision to look at documents that somehow are maintained by the DBI?
So yes, my understanding is there's an agreement between DBI and planning to allow certain members of planning to have access to view these files. And that's basically mainly in order to allow for staff to be able to look at like existing plans, previously approved plans. This helps with code enforcement violations as well to see what was originally approved. But the documents are owned by the Department of Building Inspection, and these are final plans, the stamped final signed off ones where we cannot release those, but we are able to view them in order to process applications and complaints.
Okay. When you say owned by the DBI, can you explain what you mean by that word?
So it's basically under the jurisdiction of the Department of Building Inspection. So California Health and Safety Code requires local building departments to maintain copies of plans for buildings for which the department issues building permits. And so that means the San Francisco DBI maintains building plans for inspection and prohibits duplication of these plans except with written permission and certified license of registered professionals who signed the original documents and with the written permission of the property owner. So this is something that is maintained by the Department of Building Inspection.
Do you know if anyone at planning looked to see if there were any documents that were available through PaperVision that could have been produced, but were not produced responsive to the request here?
My understanding is I believe the final signed off plans for this project are on PaperVision. I haven't seen them, but that is my understanding. But it sounds like the complainant isn't interested in those plans or going through DBI to view those. He's really interested in the ones that were sent out with the 311 notice. Okay. And that would not be on PaperVision. And we provided everything that we have.
Okay, so the final plans, your understanding, are available on PaperVision. Thank you. I have, again, I just want to clarify, I haven't seen them, but that is my understanding, but I have not seen them myself. So I may be wrong. Okay. And to the complainant, do any of those documents that we just talked about that would be available on PaperVision, are those anything that you're interested in?
I've seen them. I've written an extensive memo to the Land Use Committee, but I want to make an important distinction. DBI deals with construction in the building code and enforcing it. The planning department deals with land use issues. So I've already completed my analysis of the construction and building code enforcement. And those are questions that will be in the hearing. The one question we can't get an answer to is why did the planning department approve the illegal construction of a house on 2 lots? Because that's clearly illegal. And that's why I believe documents are being withheld.
Okay, thank you. I'm going to, I think I'm concluded with my questions of the parties. Member Stein, anything specific you think we should do here other than send this on?
Yeah, I mean, I think I'm ready to make a motion that, these are public records under the jurisdiction of the task force, and this should be heard by the full task force.
Okay, and I'll second that motion.
Am I able to ask a process question at this point?
I'll allow it.
Okay, thank you very much. I was just wondering, so if this gets forwarded to the full task force, but we're not withholding any documents, how does that improve the process, or what would the next steps be after that? Because again, we really aren't withholding any documents, and I don't know how to demonstrate that any further. We've had extensive emails to the complainant. I've spent a number of time. We've pulled in other, IT to try to see if we could find these, and they're just not within our possession. So I don't know. I just would like to know how the process would move forward in that scenario.
Yeah, that's a perfectly reasonable question, and we're not deciding that there are responsive documents that you haven't produced. We don't make a final decision of any kind in this complaint committee hearing. That's something that the task force may end up doing, and the task force could still decide in your favor. I don't know what the final decision would be. We're basically determining that these are public documents and that this is ready to be heard for the actual hearing of the matter for a decision by all the members of the task force at a task force hearing. That's what's happening here.
Okay, thank you.
Okay, thank you. So I think that we have a seconded motion, and so we can have public comment. Anyone here who wishes to make public comment on this matter?
Anonymous number 3.
Anonymous 3. Okay, Anonymous 3, let's go ahead with that. Public comment when Cheryl's ready.
Anonymous, are you ready?
I am.
Go ahead, sir.
Thank you very much. This is Anonymous number 3. It sounds like the most interesting day of committee hearings SOTF has had in a long time. I think the issue that was brought up by the chair regarding, well, if an employee of this agency has access to it, what does it mean that it's owned by someone else? I think that's a very important issue. However, maybe the complainant just doesn't care because he's already seen those other records, and so it doesn't matter as part of this case. But if there was a legal exemption, if the complainant does want to see those from the Planning Commission, and some planning employee has access to those records, electronic records are not like physical records. Many people can have custody of an electronic record simultaneously. And all the people who could access that record should be able to produce it, unless there's a legal exemption. And if there is a legal exemption that says these kinds of records can only be seen by licensed professionals, and there are some kinds of exemptions around that regarding building plans, then they should cite that exemption if the complainant even wants it. But other than that, there is an issue that if they don't want to give those, but there are other records that would reflect similar information. It's not 6721C about go get the information from another agency, because I know this came up in the last case too. It's 6725C, which says if most of the information is exempt, find out other ways that you can get what the person's fulfill the person's intent. And maybe there are those records, and maybe there aren't, but that is also a part of the Sunshine Ordinance, which is helping the person fulfill their intent or purpose when the record that they originally asked for is mostly or completely exempt. Find some other records that would do what that person wants, and maybe those do exist in this case. Thank you.
Thank you. And do we have anyone else for public comment on the matter? Sounds like we may not have anyone else. And so we're ready for a vote, I believe.
Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Stein, seconded by Chair Schmidt, that the records are public, there is jurisdiction, and the matter should be heard before the Sunshine Task Force.
Perfect. Okay.
Thank you.
Let's take a 10-minute break. And so
okay. I have 7:51.
Yeah. So let's go to 801.
All right.
And let's see. Yeah. So we will be back at 801. Okay, so Cheryl, whenever you're ready, we could do the next item.
Okay, just a second. Chair Schmidt, are you ready?
Yes.
Okay. Item number 8, file number 21144, complaint filed by Mark Sullivan against the Department of Technology for allegedly violating administrative codes sections 6721A, 6721-1A, 6725A, 6726, and 6727, and the CPRA section 6253B, C, D, 6253-3, 6253.10A, by failing to respond to an immediate disclosure request in a timely and or complete manner and failing to keep withholdings to a minimum.
Okay. All right. So we'll start. I believe we've already determined Mr. Sullivan is here. And is there anyone here for Department of Technology? Is there anyone here today to speak on behalf of the Department of Technology?
Chair Schmidt, just to let you know, notice was sent to Linda Gorell, who is the chair of the Department of Technology. Many times she does appear in these proceedings.
Okay. We're not hearing from Ms. Gorell. Okay, well, I guess.
Hello? Wait, can you hear me now?
Yes, yeah. We thought it may be a muting issue. Yeah. So you're here.
I'm sorry for that.
That's all right.
This is Linda Jarrell, and I'm the Executive Director for the Department of Technology.
Okay, great. So now we got you there. Okay, so we're going to hear 3 minutes each side, starting with Sullivan, whenever Cheryl's ready.
Mr. Sullivan, are you ready?
Yes.
Go ahead, sir.
First, I want to acknowledge that the Department of Technology did make public the records I requested. They'll be on the time frame for response under Sunshine. So the part of my complaint dealing with only the records requested is now only about timeliness. Previously, the Department of Technology has done a good job with my public record request. If this complaint is only going to be considered on timeliness issues, then I will drop my complaint. The other part of my complaint is trying to get the use of next requests by the city to comply with the Sunshine Ordinance, CPRA, and take down barriers for requesters. The Department of Technology is the city department that has the contract with Next Request. I originally tried to call the Department of Technology and talk to them about the problems with Next Request usage, only to be told that I needed to make a public record request. I tried to reach out to the Department of Technology before this hearing to explain why I filed the complaint and see if we could resolve issues and barriers before this hearing. I did not hear back. Both the Sunshine and CPRA specify no barriers. The best is CPRA 6253D. An agency cannot delay or obstruct the inspection or copy of public records. Here's a list of some issues and barriers for the public in making requests to city departments that use Next Request. In making a public record request to Next Request and giving a point of contact, Next Request automatically creates an account for you and sends you a password. In having an account, you have to agree to Next Request terms of services, of which they give you no interface to agree to the terms before the automatic account is created. To delete your account, Next Request does have an email address in your terms of service, but I have multiple times tried to delete my accounts. At the time of my complaint, I thought I did not have a Next Request account by sending the email, but they still exist. My last attempt was September 22nd of this year. There is no way of editing changes in your account. Many departments that use NextRequest do not have clear alternative email addresses for contacts with public record list if you do not agree to NextRequest terms of service or wish to remain anonymous. As an example, the Department of Technology website only directs you to NextRequest for a public record request. If you use other contacts for them, as I did for this public record request, you may fall through the cracks. All record requests become a public record as soon as they are made. Not all departments do this. 6721B is promptly available to any person. This helps requesters find requests or records and avoid duplication. I can give examples of that. Okay, thank you for your time.
Thank you. All right, now we can hear from the Department of Technology when Ms. Leger is ready.
Ms. Burrell, are you ready to speak?
Yes, I am.
Go ahead, ma'am.
I want to thank the Sunshine Task Force for bringing this request to DT's attention. Until we received this complaint, we were unaware of this public records request from Mr. Sullivan. DT has created the request in NextRequest and responded. The reason we did not act on Mr. Sullivan's request is because the request came to the DT service desk as an email and was not submitted through NextRequest, which is the assured method that DT receives the request. All requesters can submit through the service desk, and for those public records requests, there is an automatic process to route the request to the appropriate internal staff member. Those emails that come into the city must meet our security guidelines, and if they do not, they are not distributed to staff and are sent to our junk folder. When we received Mr. Sullivan's request, it contained characteristics that were deemed a cyber risk and was sent to the junk folder. After reviewing the system configuration and email properties, we have identified that the reason this email was not processed was due to a system property rule in place that was set to ignore incoming emails from senders with certain naming conventions. This rule has been in effect since 8/2015. To prevent this issue from reoccurring, we have removed one of the naming conventions that could be used by an email sender, and it will now come through ServiceNow, and this is the one that Mr. Sullivan used. We will continue the ignore rule for certain other ones that we deem to be a security risk. So the system has been corrected. We were able to investigate why this happened. We had a number of engineers on this trying to figure out exactly what happened so we could prevent it from happening again. So Mr. Sullivan is welcome to submit emails as he has to us to the DT service desk for his public records. And we have provided the information in his request and apologize for the delay. Thank
you. All right. Any questions? We'll start with Member Stein, if Member Stein has any questions.
I guess for the petitioner, I just want to ask, so you did in fact receive the NextRequest contract?
Yes, well, I said yes.
Okay,
as I know, that's their contract.
And were you able to see the fields, or have you been able to obtain information about the fields that are available on NextRequest in terms of the sort of policy decisions that get made in activating or not activating certain, I guess, what would you call it, capabilities on NextRequest?
No, I haven't had any further conversation with Department of Technology beyond the talk about getting the public records that I requested.
But that was the purpose, correct, of you understanding who's making those decisions or setting those?
Yes, that was the purpose.
Okay, those are my questions.
One of my requests was to X for the record of the person who's in charge of next request.
Okay.
Right. This is Linda Jarrell, and we have lots of people that are responsible for Next Request. Next Request is operated by a committee that determines how the system will perform. We did provide to Mr. Sullivan information on how to submit questions, and also information about who the DT records analyst is. And we also provided information about the roles that are in Next Request. But I also would like to say that to some of Mr. Sullivan's points about the use of Next Request, you don't need to go through Next Request to file a public records request. You don't need to set up an account. All the requests that DT publishes and responds to are now made public, as which is, I believe, something that he was encouraging. And the website at each department has instructions on how to make a request. We do not include the name of the records officer because it could change. So I appreciate Mr. Sullivan pointing out where Next Request might be improved. I see that as an operational conversation, which is outside the scope of a public records request.
Okay, thank you for that explication. Member Stein, do you have further questions?
No, I don't.
Okay. Seeing that it does not seem that delay is really being pushed forward as a basis of this complaint, and my understanding that it does basically come down to challenges to the sufficiency of Next Request per se. I don't think I have any questions for the parties right now, and so it does look like Mr. Sullivan has put forth some complaints about Next Request, and he's made some specific descriptions of areas where there may be problems. I guess we just want to consider, do we just send it forward? Do you have any thoughts as to resolution here, as we said as a committee?
Well, I was going to say, I think, two things. I think you're correct. Two things have been put on the table here. One is the Department of Technology's response to request. Another is kind of more generally the problems with using Next Request in fulfilling both the letter and the spirit of the Sunshine Ordinance or the California Public Records laws. And I think these larger policy questions, which Ms. Durrell has said are operational questions, I think are harder to filter through a records request violation and maybe better handled in some other way. And I think this has been, brought before the task force attention a few times that there are problems with Next Request. So I don't think we should find it sounds like the actual records request complaint could possibly be disposed of here, because, based on what the petitioner has said. And I'm just wondering if there might be some better way for the petitioner to bring these other policy questions before the task force. I just don't think it can be well handled or comprehensively handled through one records complaint.
Well, I would agree with you that there may be, a different way that he could proceed on this, although it's sort of his option as to where he goes, and if it's a, I'll call it a cognizable claim before us, and it may be that we've heard, next request complaints before, and we may be just going through the same process. We may need to be, like responding. If somebody tries to, I guess in this situation, he didn't actually try to use, I think he submitted the complaint maybe through both mechanisms. I'm not sure, but when he didn't submit it through next request, they put him into a spam folder, which is, obviously problematic. But I'm not sure if we want to, well, I guess in his situation, he didn't use next request, so where's the harm? It's kind of where's
I guess what I'm, yeah, I guess what I'm saying, I feel like the complaint is trying to also serve as a vehicle to have a broader policy question about issues that don't entirely come under the complaint. And the complaint, as the petitioner has said, is, has pretty much, he's willing to drop it because the only thing remaining is the timeliness issue. And I guess I'm maybe appealing, or I would like to hear from the petitioner maybe about, would they be open to other ways of bringing this forward? I just don't think this is going to lead to, bringing it through this case is going to lead to any substantive or comprehensive recommendations about what needs to change about next request. So that's, I guess I'm wondering if the petitioner would like to drop this complaint and try some other method of bringing up these questions or raising this issue. If not, I guess we can send it forward on this issue of timeliness.
And I don't know if I would be necessarily thinking that, you go ahead and ask him, but I think that he probably figures that this is a pretty good way to try to get this issue looked at. But I would actually say, ask him right now. That's a good idea.
Do you want me to respond now?
Yes, please. Yeah.
Okay. Yeah, if it's just going to be a matter of timeliness, then I'm not interested. The purpose of my public record request was to engage the Department of Technology. They have so far not. I do think that their use of next request violates parts of the Sunshine Ordinance, which is what I spelled out in my complaint. So, the only other thing I could do is just drop that part, the public record part of my complaint, and then kind of resubmit it. Because I still believe that it violates a number of parts of the public records. Like it needs to be easily searchable by a major internet engine. It's not. I already gave an example in the complaint about that, and I even tried to use Next Request's own search engine, and it fails. This is all for searching for public records that are available to any person, with no barriers. An agency cannot delay or obstruct inspection of a copy of record. They can allow Next Request to obstruct the inspection or copy of record. If I can't search for the records in Next Request efficiently, then that's an obstruction. If the agency is not, there's other parts of it too, where disclosure of records implements a system that permits making records available to the largest non-profit, proprietary public computer network consistent with requirements for security of information. This is 6721-1B3. And I don't know if they do that. I mean, they have next request to do that.
So this is Linda Jarrell, and what I'd like to suggest, and I don't know if Mr. Sullivan would agree to this, but I can have Arlene sit down and have a virtual meeting with you and show you how to do searches with next request. I just did one just a minute ago and just looked up all the requests that were asking for contracts, which that seems to be the most popular public records request that DT gets. So you have a lot of hits there. So it does have a search function. It's at the top of the screen, and you put in a keyword, and then you hit go, apply filter, and it goes. So I can have Arlene talk to you about that if you like, show you how that works.
No, I did that.
I want to, Mr. Sullivan, let me interject here.
Okay.
You can choose to take any of these options, and if you want to do what Ms. Jarrell just suggested, you may, but I do not want you to feel like we're pressuring you to drop your claim. We may give you suggestions that you might take, but if you have a valid complaint that could be addressed before the task force, I don't think you should feel like you should be talked out of it by any of us here. And
okay, so
it's up to you. It's up to you.
And I hope you'll take some public comment before accepting or determining anything about a drop.
I just want to say I'm not saying you should drop it. I'm just saying I'm trying to imagine what the conversation looks like when it's filtered through this case and we go to the task force, and how we can address these criticisms that you have of next request, which, I think are really good critiques. But I'm just wondering how we would handle it through the filter of this case, and if it's the best way to do it. That's all I'm saying.
Now, Mr. Sullivan, the floor is yours if you wish to respond to any of that.
Yeah, I mean, I think I have a valid thing. The next request violates certain parts of the Sunshine Ordinance. And that's part of my complaint. And I spell it out. I'm willing to continue on with the complaint and to sit down with the Department of Technology and see what happens. And then if everything gets resolved, then we can drop the complaint. Or if it doesn't, then we can continue on with the complaint. I mean, I know how to do searches and stuff. I randomly searched a name, Dijar Durden, from a next request, a number. And I put that in the search box, and the search did return records and requests for that name, but the request number that I got the name from did not show up in the search. So, I mean, that's a problem.
Yeah,
and
absolutely. Okay. Thank you, Mr. Sullivan. Yeah, I mean, I think that we just, and we're back to discussing among the members. I think that, Mr. Sullivan can go forward with any of his options here. I'm not sure if, on the other hand, we could make recommendations, but I don't think there's, I don't think that I can see doing anything other than sending this to the task force. And if the task force has difficulty with it, then the task force has difficulty with it. But I mean, if we want to somehow pick things out and tell task force, we think this is a big issue, but this isn't, etc. I don't know if that's necessarily what we need to be doing here. I think it probably just should be sent forward. And we wouldn't want to have Mr. Sullivan drop his complaint and then go to the Department of Technology, because it's probably better if he had an existing complaint, if he wants to be able to have a successful result in talking with them.
Do you want to make a motion?
I'll be happy to make the motion if you think we're ready. Although any more thoughts, I'm happy to hear. But I will make a motion. We move this matter to be heard before the full task force on all the contentions made by the complainant. This involves public records, and we do have jurisdiction over the matter.
Okay, I second it.
So now when Cheryl's, or actually I should ask, anyone here who wishes to make public comment on this matter? I know there was an interjection earlier.
Yes, please.
Okay, there's number one.
Peter Warfield.
Thank you. Any other public commenters? Okay, let's go ahead with Mr. Warfield.
Mr. Warfield, are you ready?
Yes, just let me know when to start.
Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com. Also P.O. Box 170544, San Francisco, California, 94117-0544. I think that there is a stunning panoply of violations going on here, including some which the head of DTIS has acknowledged. First of all, if this is supposed to make getting records easier or even possible, Mr. Sullivan has testified that he made a very specific search for a specific record that presumably was in the database, and he couldn't find it. That is indeed, as Chair Schmidt has said, a problem. What I found stunning, and I think this needs to be both publicized and fixed, is that we heard from the head of DTIS that the whole thing is run by some kind of an anonymous committee, none of whose names we know or what they can determine. And the most stunning thing was they decided somehow, or the system decided somehow by how it was set up by these anonymous folks or anybody, that this request of Mr. Sullivan was some kind of a security risk. What are we talking about? A bombing? Are we talking about what's the white powder that is poisonous that comes in envelopes? What are we talking about? There was absolutely no specificity as to what the filter was, what the considerations were, how they were used or applied. We just heard that his request went to junk. And that is stunning. That request should be considered like any other as a request that came through a legitimate means. The Sunshine Ordinance specifies that you can make requests in a variety of ways in 67.21, orally or in writing or in person, and so on and so forth, including email. And to accept that folks can just shove it into a junk file and ignore it based on their own decisions. I have 5 seconds more. on my clock based on their own decisions that we don't even know what they are. And we hear that something has been fixed and now he can get through. Well, what about all the other people? What about all the other people who didn't know what happened and just gave up? This is a stunning violation on multiple levels and definitely needs to be reviewed on all levels possible, certainly the ones that are included in this complaint. Thank you very much.
All right. May I proceed with my complaint? As my comment?
Oh, you have a public comment?
Yes. Yes. May I?
Just a moment, sir. Are you ready to begin?
Yes, I am.
Go ahead, sir.
Yes, my name is Sergey Severinov, and I'm a citizen and resident of San Francisco. And as an American citizen, I'm aware of the Bill of Rights and of the American Constitution, U.S. Constitution, which gives the citizens the rights to petition the government. This is one of the fundamental rights under the First Amendment. Well, apparently in its infinite wisdom, the city of San Francisco has figured out how to deal with those petitions. It puts them in the spam folder. It's utterly ridiculous that the Department of Technology is the one that's doing this, pretending that this is a security risk. And as a citizen and as an immigrant, that's my experience with the city government. When you are appealing to them, they put you on the spam folder in many figurative and literal senses. And this is in particular concerns the Department of Police Accountability. You are, as a citizen, in their spam folder forever. Thank you.
Okay, thank you. I think that may be all the public commenters. So we should be able to go ahead with the vote, Joe.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein, to have the matter heard before the Sunshine Task Force on all the contentions made by the complainant. This involves public records, and there is jurisdiction over the matter.
Good.
Okay, just give me a second to Shall I read the next item?
Yes, please.
Item number 9, file number 21136, complaint filed by Anonymous against Catherine Porter, Elizabeth Fulbrith, in the Office of the City Attorney for allegedly violating Administrative Code Section 6721A and B and 6725B by failing to respond to a request for public records in a timely and or complete manner.
Thank you. Okay, do we have this anonymous, and this is not our anonymous 3, this is a different anonymous. Is this anonymous present? Is this anonymous present in the case versus the city attorney? Okay, it doesn't sound like the complainant is here.
You might want to say the name and the number and who's involved so that they might recognize it.
Thank you. Yeah, please don't speak out of turn. Okay, last call for this anonymous. All right, so the party's not here. I think that this I have this sort of vague memory that this may have occurred with this party before. But I'm not going to rely on that.
Just so you know, Chair Schmidt, I was very specific about this particular complaint to make sure that I got the correct petitioner noticed and sent them the agenda packet.
Yeah.
So I was very careful about that.
Well, I'll just float the idea. Maybe we want to what did we do last time in a situation? Did we?
In a situation where the petitioner is not available for the complaint, we move to table the matter and close the file.
Okay. Yeah, I think that's. Yeah, let's do that. Member Stein, any thoughts otherwise?
No, I think that's a good solution.
Okay. Yeah, let's do that. And so that will be let's table it and close the file.
Chair Schmidt, are you moving?
Yeah, that'll be a motion.
I'll second it.
We want to take public comment on this?
Yeah, let's go ahead.
Do we have public commenters on the motion to table the matter and close the file?
Okay.
Last call to speak on the motion to table the matter and close the file. Chair Schmidt, it doesn't look like we have public commenters.
Yeah, I think that this complainant, maybe they just were satisfied with what they got, and this is where we find that out. And yeah, okay, let's go ahead with a vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein, to table the matter and close the file.
And so when you're ready, Ms. Leger, we will hear the next matter.
Item number 10, file number 21146, complaint filed by Sergey Zveranov against Sarah Maunder and the Department of Police Accountability for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request for public records in a timely and/or complete manner.
All right, so we have reviewed the documents that have been submitted. Let me ask, is there someone present on behalf of police accountability? The respondents. Is there anyone here on behalf of the respondents? That's interesting.
Aye.
Okay. Well, actually, that's we did. I do know that they had requested a continuance.
Oh, this is Sarah Munder. Can you hear me now?
Oh, here we go.
I'm so sorry.
All right. So we have, thank you for appearing, Ms. Maunder. So we have both parties here. And so we will go ahead with, we've read the file. So anything you want to add, any kind of opening discussion of the matter. We're going to give you 3 minutes each, starting with the complainant. And so when Cheryl tells you that she's ready, Mr. Severnov, that will be when you get your 3-minute presentation.
Mr. Zverinov, are you ready to begin?
Yes.
Go ahead, sir.
Okay, I submitted 2 requests for records from DPA, one followed by the other, and they both ask for all the materials of investigation of my complaints, and specifically also the second point that they asked for, all the records that pertain to me, myself, that mention me, myself, Sergei Severnov. In response, the Department of Police Accountability said that all their records are exempt, except for the minor ones that they just disclosed, which basically just copy my complaint and a one-line disposal of my complaint. I think this is inadequate, and it basically violates the spirit and letter of the law. The complaints that I filed to the SOS is basically says that one of the things that I'm really asking the department is to reveal how they investigated my complaints and everything they said about me. In the process of my interactions with the Department of Police Accountability, I have encountered multiple instances of bias, racial and anti-immigrant bigotry. I wanted to know where this comes from and how they investigate my complaints. I have been stonewalled in those requests. Now, one of the things that the Department Police Accountability did plain wrong is that they actually narrowed down the search to the database of the police misconduct investigations. This is completely illegal, and that that actually rules out their search for all the other written documents, including memos, internal documents, and emails. I have provided, as an example, an email that I received from one of the police investigators that just addressed to me and has no exempt content in it. Furthermore, any exempt content that they have has to be redacted. The San Francisco Sunshine Ordinance says that no records can be withheld in its entirety. That's the quote: "No record shall be withheld from disclosure in its entirety." Okay, so they can redact the documents and they can provide whatever investigative content is there. If this is what the Department of Accountability is allowed to do, then they de facto remain a secret agency in the San Francisco administration. All right, that's it. What I want.
Okay, thank you. All right, and now when Cheryl's ready, we can hear from Ms. Maunder.
Ms. Maunder, are you ready?
Yes, I am.
Go ahead, ma'am.
Thank you. Excuse me. So good evening. This matter is about an immediate disclosure request for San Francisco Police Department misconduct investigation records. It's also for DPA employee personnel records and records associated with 7 police misconduct complaints filed by Mr. Severnov since 2009. So for anyone unfamiliar with our department, DPA is tasked with investigating all officer-involved shootings and also any complaint of misconduct by a police officer. So we essentially conduct personnel investigations. We first received Mr. Severnov's request by email on October 20th as a standard public records request. That was request number 1 that I believe he was referencing. Then we received the exact same request through our portal, but rephrased as an immediate disclosure request. It was for the same content. We began working on the request on October 20th. And on October 22nd, when we received the resubmitted request, we sent a timely letter denying immediate disclosure because the request was not simple, routine, or readily answerable under Admin Code 6725A. The request required us to go through records dating back to 2009 for 7 different investigations to see if any of the cases were in fact disclosable under the California Public Records Act. If you've heard of SB 1421 records, we had to examine each case to figure out if one of the very 4 special exceptions to our strict confidentiality laws applied. We found that none of those 4 exceptions applied. They are for the most serious of cases, and none of the categories aligned with the investigations that we conducted in connection with Mr. Severanov's complaints. So we sent him, in his capacity as a complainant, copies of records that he's entitled to. He was not sent those records in his capacity as a public records requester, but rather as someone that was a party to a complaint. We sent an extension letter. We thought originally that we would be able to fulfill the request within 8 days. It was a little bit over ambitious. We said that we would follow up with him by November 1st. We were unable to produce the records by that time, so we sent several extension letters, I believe 2 extension letters, and we explained what documents we were looking for and needing to pull from archives and digitize, and we eventually sent him, I believe, actually, it's outlined in the letter I submitted, but at least 14 files we sent, and we explained which ones were coming and when, and they're all summarized and listed in the letter that we sent. So at this point,
time is up.
Thank you.
Yeah, thank you. Thank you. All right. Now we may have questions by the members. I will defer first to Member Stein.
Okay, so I guess I just have a couple questions for the respondent. So are you saying that you believe that your department is not subject to any public records requests?
Oh, not at all. That, of course, we're subject to public records laws. Absolutely.
Because you say you only gave him records because he was a party in this process and not as a public citizen, even though he made a public records request. Can you explain that a little bit more? Like why are these not subject to public records requests in your why is nothing in his request subject to a public records request?
Absolutely. He's absolutely free to make a public records request. The records are not disclosable under the California Public Records Act because they are peace officer personnel files that are governed by the Peace Officer Bill of Rights in Government Code, starting at Government Code 3300. And it's also governed by Penal Code 832.7. And so we are not at liberty to disclose any police misconduct investigation records to the public unless 4 special categories apply. So none of those categories applied. So basically they're public records, but we cannot disclose them. And there are a couple types of records that we can disclose if you were a party to the complaint. And Mr. Severnov happened to be a party to the complaint as the person who originally filed the complaint. And so because he was involved, we were able to send him findings letters associated with those investigations and his original complaints, but we are not able to share those with anyone else that makes a request. So yes, they are still public records. However, they are exempt and we are prevented from disclosing them to the average person.
So are you saying too that any record, including say emails, that may have no information about the personnel who are being investigated, but may mention Mr. Severnov, are also not subject to, they're not public documents that could be disclosable?
No, I'm not saying that.
Okay, so then can you tell me what searches, or how did you search for any records pertaining to Mr. Severnov as asked for in item 7 of his request, and how those searches were conducted?
Sure. So I looked through our database for the case records, And then our case database is actually linked to our email system. And so mentions of Mr. Severnov would come through that database as well. And so I did not find any responsive records of emails mentioning Mr. Severnov to produce. I also made verbal requests of the persons that were investigating his current complaint.
Okay, those are all my questions.
All right. Now, I also have a couple of questions for the respondents. And really, it has to do with just getting the scope of what we're dealing with here. In terms of all the documents that were requested, if you look at the requests and any documents that exist that would be responsive to that request, there were some documents that you withheld under the peace officer exemption. Is that correct?
That's correct.
Okay. And then there's another category of documents that are given to Mr. Severnov because of Mr. Severnov's status as a complaining party, correct?
Yes, those are from the same batch of documents.
And then other than the exempt peace officer documents and the documents that were given to Mr. Severnov because of his status of a party, were there any other documents that were responsive that you either gave him or that you withheld?
No, there were no other responsive documents provided or withheld.
Other than the first two categories, that peace officer exempt or they're disclosable because he's a complaining party, right?
That is correct.
Okay, that's all the questions I have.
Thank you.
Okay, so what should we do with this one? Member Stein?
Well, these are public records, some of which in theory would be under our jurisdiction and not exempt. So I would move it to the full task force.
Yeah, I think before I'll take that as a motion. Is that a motion? Or is that a motion?
Okay,
not yet.
It can be.
No. Okay. I was going to say, if that's a motion, I'm going to answer your motion in a minute. But I mean, we may be testing, whether they're exempt. I'm not sure if we're actually testing whether some of the records are exempt. In terms of the records that Mr. Severnov got, he got them, so I don't think they're contested. So I'm not quite sure exactly what you're left with here. But on the other hand, we don't decide. We don't decide the complaint. So therefore, I second your motion.
Okay, I was just going to say, I mean, there were emails between him and members of that of the DPA that weren't produced. That he maybe
that's
had
because
copies of, but they weren't produced. So
you're saying that the emails you're describing, we know about those because of Mr. Severnov told us, right? Is that what you're saying?
Yeah.
Okay. And so
I'm kind of, that's what makes me feel like it should go forward.
Well, okay. Let me just make sure. Oh, I agree. It should be moved forward, but I'm just trying to figure out. You're saying they say there's no emails, but he shows us actually there are emails. Why didn't they produce those? And so you're saying that we don't really trust when they say there were no emails. That's kind of where you're going on that, right?
Yeah.
Okay. Fair enough. Okay. I still second you. I mean, yeah, I think, and to explain to the parties, we can't make a final decision here. This is a committee. And we look at the complaints. We determine, are there public documents here? Are there, what's the nature of the documents? Do we have jurisdiction? Does the task force have jurisdiction? But ultimately, this would be decided in terms of a final decision only by the full task force at a meeting of the full task force. And so what our motion does is it would move this forward to another hearing where the full task force can make a ruling on it. So that's what we're doing. Okay, so we have a motion. We could then hear public comment on this. Ms. Leger, whenever you're ready. Oh, I should ask, is there anyone here who would like to make public comment on this matter? All right, we got one. Who's that?
Ms. Varina, you make public comment on your own case.
Yeah, other than the Mr. Severnov, yeah, we don't allow the parties to do public comment. They get to talk during the case, but we've already talked to you and asked you whatever questions and heard from you. But this is for members of the public who aren't parties. Anyone else? Is there anyone? Oh, I understand. Yeah, but now you know that's the rules, and so but yeah, there we go.
There's nothing in the rules that prevent me to participate in the public comments on my matter.
Yeah, there is.
Yeah, Chair, what rule is that? The parties can't speak in public comment on their own case.
I think it's part of the complaint procedures.
Yeah, there's a procedure that says, and we're just telling you what the established procedure is, that we can't and we won't allow you to speak in public comment on your own matter. Yeah.
Chair
So
Schmidt,
is there anyone? Yes.
before we go on, I want to just clarify what this motion is. Laura moved to send the case to the full task force. Is there jurisdiction, and do we consider these records public?
I consider some of the records public, which is why I move it. So there are some of the records that are asked for are public.
And what about jurisdiction?
Yes.
Okay, is there anyone here to give public comment on this matter?
Yes, please.
All right, there we go. We've got one. Anybody else with public comment? All right, let's go ahead with that commenter.
Mr. Warfield, are you ready to begin?
Yes, just let me know when to start.
Sir.
Did you say start?
Yeah, I did.
Peter Warfield here, Executive Director, Library Users Association. Library Users 2004 at yahoo.com. And P.O. Box 170544, San Francisco, California, 94117-0544. We're not a party to this. We're not familiar with this case, particularly other than what we have heard this evening. But of course, we're very concerned in general with open government issues and so on. So I would say it's a good motion, and we support it, but I would urge you to provide the specificity that presumably you have done some work here to help make clear. In general, I'm always in favor of clear and thorough documentation of pretty much everything, because you are you're doing important work, and that work can help others and everybody with respect to what's going on with Sunshine and how all that works. So I think Member Stein made a cogent point about there being records, that there are records, and the legitimacy of how they have been provided or not provided or partially provided needs to be adjudicated. But it sounded as though that was a significant finding from the discussions that you've had here. And it seems to me that it would be helpful, as I say, to include maximum information and detail, especially when that might help clarify, guide, assist the full task force's consideration. So I would urge you to add a little bit of that detail that you had pointed out as the reason for going forward, or a reason for going forward, to help the full task force and presumably everybody else, including the public, but in overall support the motion. Thanks very much.
All right, thank you. I don't think there was anyone else for public comment on this. So we could go ahead with a vote.
You ready? Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Stein, seconded by Chair Schmidt, to find that the records are public, there is jurisdiction, and move the matter to the full task force.
Okay, so when you're ready, Cheryl, we can have a brief, just a mention of number 11, although it's going to be abbreviated.
Item number 11, hearing on proposed changes to the task force procedures and bylaws.
Okay, again, as I had described earlier, this is really not a hearing, and there will be no actions, no motions, etc. What happened was, partly due to my fault, not all the documentation made it into the file in time to look at what I had hoped to have available, which is, I will describe again. There was a November email from Anonymous 3. There was a November email from Sullivan describing recommendations as to changing certain rules and procedures, and I wrote a response from, on my own behalf to their recommendations, substantive. And so those three documents, we could have been looking at them. I think that what I will do is get my document out to hopefully earlier than just when the package goes out for the next complaint committee, so people can look at what I have to say, and I will include those two with it. And it'll go not just to this committee, but to certainly those two parties. And at least by the time of our complaint committee, it will be available in due course to everyone who might be involved in the next complaint hearing. So that is what this matter is at this time. Member Stein, is that is that satisfactory as an explanation, as a mea culpa partly?
Yeah, no, that'd be great.
Okay, thanks. It's since there are no actions of any kind, I don't know if there's any need to say anything in terms of public comment on the matter.
Every item on the agenda has to have public comment opportunity, please.
Number 11. Is that I can well, Cheryl?
Yeah, Chair Schmidt, he is correct. If it's on the agenda, members of the public.
Okay, that's fine. So public comment. I think we got one. Any others? All right, let's go ahead with our public commenter.
Mr. Warfield, are you ready?
Actually, I'm not. Do you mind waiting just a moment while I get to my timer? Sorry. Oh, just almost. Hello?
We're here.
Okay, thanks very much.
Are you ready?
Yes.
Go ahead, sir.
Thank you, Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and PO Box 170544, San Francisco, California, 94117-0544. First of all, I'm glad you're considering what to do to improve the functioning of the Sunshine Task Force and any of its component parts. Second, I think it would be useful in this case and probably in many others to make public before the agenda the material that's involved when you have it. And in this case, it appears that there are multiple things that you intended to include and have all set to go. And I believe 3 things were Sullivan's recommendations, which I believe were in the agenda packet, Anonymous's, and your chair's response. So I think that would be a good idea to make those available for discussion, but to do so promptly. At this time, I'm making an oral request for that information to be provided to Library Users Association so we can see where things stand currently with these public comments. One of the things that, well, I should say that I think you have a lot of very excellent folks who have worked with Sunshine and some who have, in varying degrees, over varying amounts of time. And in general, it's a good idea to listen to their very often, maybe usually, excellent suggestions. In this case, there are many suggestions, but what I'd like to say is that I wish that the task force would take a more global perspective and basically to do a broad analysis of how things are working and what might be going wrong and where there could be improvements, not just in things that affect complaint process. To focus this way is almost as though you have a medical system
27 seconds.
That's being overwhelmed with COVID and only looking at how you can handle the patients coming in the door and maybe get them out quicker. That's fine. It's worthwhile. But the larger issues in COVID are not just who's coming in and how to cure them or fix what they've got, but the much larger issues, what's the cause of it, how is it spreading, what can you do on a broad scale. And likewise, the Sunshine Task Force should do that with respect to all of its operations broadly. Thanks very much.
Thank you. All right. I guess we can move on to number 12. Cheryl?
Item number 12, announcements, comments, questions, and future agenda items by members of the complaint committee.
I have nothing on top of what has already transpired today.
I don't have anything to raise at this point.
Okay. So that's everything right there. What do we do next, Cheryl?
Public comment.
Are you ready?
Mr. Warfield, are you ready?
Yeah.
Go for it.
Thank you, Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, excuse me, San Francisco, California 94117-0544. Just as a reminder, I want to repeat the request that I just made at the previous item for the documents that Chair Schmidt mentioned as should have been in the agenda packet. And I would like to have those sent to Library Users Association at one of our addresses. Announcements, comment, future agenda items in particular. This is a very valuable and important section of any agenda, and it gives you the opportunity to suggest things to put on an agenda in the future. What I would like to suggest for a future agenda item is what I said, and that is to have a broad view with solicitation from the public for what they think has worked well, what has not worked so well, what hasn't worked, what are some problems with Sunshine Task Force. I believe there are a lot of things that can be looked at, and I would certainly say to start with what's going on with what seems like a huge landslide, avalanche of complaints and complaint backlog. Some of this may be because there's a lot of violating going on. And I think you need, as a doctor might do, to understand what's happening. What are these symptoms potentially of, or actually of, and what needs to be looked at with respect to that? Do people not understand what the law is? Is there a higher authority from whom scofflawism is happening, or encouraged, or recommended, or shown by example? Is there inadequate training and education of the people who are most likely to respond to document requests or run meetings? Is there a lack of penalties? Does the task force itself do things that diminish its effectiveness? Are there things it could do to increase its effectiveness in general? I would say, for example, publicity, making public its decisions widely, and writing up findings of its own. Are there difficulties with the law? Because recall, you have the right under 67.30, broad right to recommend, to report, and even to recommend changes to the law. So that's what I would urge you to do. I'm not saying to stop anything that you're doing. It's good that you're doing stuff. Why not do this as well? Thanks very much.
All right, thank you. Next item, Cheryl.
Item number 13, adjournment. I have 9:17.
Great. All right.
So who moves, who seconds?
I'll move to adjourn.
Second.
And Victor, I think you can probably clarify this for me maybe a little bit better. You know, Mr. Warfield's request to have the information that was to be provided in the in item number 11, the changes to the procedures. He's asking that they be made available to the public before an agenda, and I don't think legally we can do that. We cannot make information available to some committees or some groups, but not available to the general public as a whole. Victor, am I correct on that? Victor? Anyway, that's how I understand the law to read. You guys have any comment on that?
Well, I'd like to comment.
I wouldn't really have a sense of certainty on that. It does seem like it's a I mean, it's a reasonable request, but you're right that maybe you just can't do that.
Yeah.
It's outside the it's the basic, you know, the procedures that do exist. Yes.
Okay, I am going to shut down the recording.
Maybe go to Victor, see if he could get an answer to that when he's available. He may have.
Sorry, I stepped away for a moment. May I ask, what was the question?
Mr. Warfield has requested that the information that was to be provided in item 11 regarding the proposed changes to the procedures and bylaws, Mr. Warfield has requested that it be made available to his group, Library Users Association, before it gets agendized at the next complaint committee hearing. And my belief is that we can't prioritize one group over the general public.
I would consider it a public records request, and we would provide what's available at the time of the request. And if anything becomes available at a later time, it would be provided as part of the packet. It would just be a simple public records request, and we would provide what we have at the moment the request is made.
That makes sense. That makes sense. All right, I am shutting down the recording.